Classified Crime is on the case of Sarah Boone, and today we're going to read over the written closing argument submitted by Brian Boone in the family court case. Let's take a look. Okay, this was filed 8/28 at about noon. Petitioner's written closing argument. Petitioner Brian C. Boone, in quotations, former husband, I love that they did that, respectfully submits this closing argument in support of his petition to modify the parenting and supporting orders. And in opposition to the respondent's requests, states as follows. 1. The evidence at trial and applicable law overwhelmingly support granting the relief Mr. Boone seeks for the benefits of the party's minor child. 2. Since the respondent's former wife, so they gave her a little quote-unquote too, incarceration in February 2020, Mr. Boone has single-handedly provided a loving, stable home for the child covering all financial, emotional, and logistical needs without any contribution from the former wife. Exactly. That is a beautiful thing to open with. In contrast, the former wife, now a convicted M serving life in prison without parole, wow, has been completely unable to care for or support the child, having had no overnight contact since her arrest in 2020. So she's really not going to like that they threw that in there, but facts are facts. Regardless how you feel about your quote-unquote pending appeal, which I will post. They denied the motion for extension of time. I'll post that on the tabs later on. 3. At trial, the former wife stipulated that Mr. Boone could relocate the child to Gainesville, Florida. However, she did not agree to Mr. Boone's proposed parenting plan that provided the sole parental responsibility for Mr. Boone, 1 monthly visit with the child and the former wife, and 1 weekly phone call between the former wife and the minor child, which is more than reasonable. 1 visit a month and 1 weekly phone call. And I would hope that the judge, if she agrees to Brian's proposed changes, so I think the judge should add that stipulation only if the child chooses. Now, I know Sarah will say, oh, he does want to. He's a different person around his dad. Brian doesn't want him to talk to me. He's keeping him from me. But that's just her projecting what she wants onto the child. It should only be if the child chooses, I believe, personally. 4, the former wife has shown no genuine accountability or remorse. This is 100% true for the actions that led to her incarceration. The evidence demonstrated that she continues to deflect blame for her predicament rather than take responsibility. This lack of insight into her own wrongdoing heightens concerns about her judgment and fitness as a parent. Boom, mic drop. That is exactly how we all feel. Well, at least me. I'm pretty sure you guys do too, from the comments I've read. 5, a parent who cannot acknowledge such a grave error, and I'll let you read that word, that left her imprisoned for life, is ill-suited to make decisions affecting a child's well-being. Florida's public policy strongly condemns violent criminal behavior. A parent incarcerated for a heinous intentional act cannot simultaneously fulfill the obligations or enjoy the benefits of an active parent. In fact, 6, Florida law recognizes that a parent's lengthy incarceration for a serious felony is so contrary to a child's welfare that it can justify termination of parental rights, and it cites case law there. While Mr. Boone is not presently seeking to terminate the former wife's parental rights, this principle underscores how profound the former wife's situation has undermined her role in the child's life. So, That means he could seek it at a later time. And that's kind of like a little a cautionary tale there for Sarah that, hey, I could take this further and seek complete termination. 7, Florida law presumes that shared parental responsibility is ideal, but that presumption yields when shared decision-making would be detrimental to the child, not the other parent, the child. Here, sole parental responsibility in the father is not only warranted, it is essentially compelled by the circumstances. 8, the former wife has been entirely absent from the child's life for over 5 years and will remain so for the remainder of his minority. By virtue of her incarceration until life's end, she is unable to participate in day-to-day parenting or any meaningful decision-making. Because she's shown her decision-making skills are lacking. And yes, even though she defines it as one obscure incident that doesn't define her, turns out it does. 9, Mr. Boone has already been exercising sole responsibility in practice since 2020 out of necessity, no fault of his own. Formalizing sole parental responsibility in the father is necessary to avoid any confusion or conflict in decision-making going forward. 10, awarding Mr. Boone's sole parental responsibility will serve the child's best interest. The child is thriving under Mr. Boone's sole care, which provides stability, consistency, and safety, all of which would be jeopardized by giving the incarcerated former wife any decision-making authority. I think she should continue to be referred to as the incarcerated former wife moving forward at all times. 11, it is simply not feasible for Mr. Boone to consult with a prisoner serving life without parole on major decisions about the child's education, medical care, or general welfare, especially when the imprisoned parent will have no financial stake or personal time investment in the decision itself. 12, more importantly, it is not in the child's best interest to do so. The former wife's inability to accept responsibility for her crime raises serious concern about her judgment. The trial evidence showed that rather than expressing remorse or cooperating in the child's welfare, she has made unfounded inflammatory accusations against Mr. Boone. For example, accusing him of parental alienation simply because he has protected the child from exposure to trauma. Yes. This is so well written and concise and to the point. See how effective that can be? Such behavior reflects a mindset that is not conducive to healthy co-parenting or prioritizing the child's needs. 13, consistent with the above, Mr. Boone's proposed parenting plan. 13, consistent with the above, Mr. Boone's proposed parenting plan should be approved as it is tailored to the child's best interests, which is what Sarah failed to consider. She was considering her best interests. Under these unique circumstances, Mr. Boone's plan is generous yet prudent. It permits the former wife to maintain a relationship with the child through supervised monthly visitation at her correctional facility and weekly telephone calls. This plan ensures the child can have some contact with his mother, preserving their bond, which she is so fond of mentioning, to the degree possible without compromising the child's safety or welfare. I have a feeling the judge is really going to like this. 14, the former wife's durational alimony award should be terminated retroactive to the date that Mr. Boone filed his petition to modify in April of 2022. And I'm currently recording a video recapping that, so that will be out in the next few days. Due to the substantial change in circumstances and the elimination of her need for support. Exactly. The jail is your support now. The state of Florida taxpayers are your support. 15. Here, the former wife has no legitimate financial need for alimony at this time. Her incarceration means that the state of Florida, at taxpayer expense, is providing all her essential needs, including housing, food, clothing, and medical care. She pays no rent, no utilities, no grocery bills, no insurance. The primary living expenses that alimony is designed to cover have been entirely assumed by the prison system. Any minimal personal expenses she might have, such as commissary items or phone minutes, are negligible and certainly not expenses the former husband should be ordered to finance. Thank you. Exactly. 16. In short, the entire premise underlying the original alimony award to assist the former wife's postmarital living expenses and transition to self-sufficiency, which she failed at miserably, has been upended. Given her life sentence, she will never re-enter society or incur the normal living costs that the alimony was intended to defray. And of course, she would interject that, what about my appeal? Yes, but how many times in her letters has she said, crystal balls don't work? No one can predict what will happen. We have to base things off of facts as they are now. 17. Put simply, the former wife's incarceration has extinguished any reasonable claim of need for alimony, and it would be inequitable in the extreme to force Mr. Boone to keep paying. And moreover, it would take away from the child. 18. Moreover, the former wife's incarceration and conviction amount to a substantial change in circumstances that was not contemplated at the time of the divorce. 19. The former wife stipulated that Mr. Boone does not owe him child support since she was incarcerated in February 2020. So they agreed on that one thing. However, Florida law does not automatically extinguish a parent's duty to support a child due to incarceration. See case law listed. A parent's duty to support exists as a result of parenthood and is not erased by a criminal conviction. 21. In other words, the former wife's incarceration did not terminate her obligation to contribute to the child's support. It merely rendered her unable to do so. The unfortunate result is that Mr. Boone and the child have borne the full financial burden with zero assistance from the former wife. For over 5 years, the former wife has paid nothing toward the child's needs. She also failed to exercise any visitation. And even if Mr. Boone did facilitate in-person or video visits, he's having to facilitate it. She cannot take the child for any length of time without his supervision. He would have to be there. 22. Mr. Boone testified that between February 2020 and April 2022, he provided the former wife with direct monetary support, averaging $600 per month, in addition to paying $240 per month for a mini storage unit on her behalf. Not to mention, he packed everything up for her, which the cost of moving services is high. 23. During the same period, the former wife had a child support obligation of $367 per month to Mr. Boone based on his exercise of 100% time sharing, an imputed income of $60,000 annually to him, and minimum wage inputted to her. And remember, we saw that on the child support worksheet that they completed in the original divorce. Miss Boone was not employed at that time either, and they do calculate based off a 40-hour minimum wage salary, a child support obligation. 24, extrapolated from February 2020 through the child's age of majority in October 2028, a span of 104 months, that obligation totals $38,168 in child support owed by the former wife. Child support she will never satisfy given her life sentence in prison. So they're arguing that based on that minimum wage 40-hour amount of $367 that he probably calculated from the worksheet and attached into the record. from the time of her incarceration through the child's 18th birthday, she would owe this much money, $38,168, and she will not be able to pay it. Even without giving Mr. Boone any credits. So even if they don't count his payment on her storage unit and his $600 a month, and assuming that Mr. Boone owed the former wife the maximum amount of $26,000 in alimony arrears from February 2020 through the filing of the petition to modify, not through the current date, the filing of the petition to modify in April of 2022, the former wife's child support obligation alone more than offsets any such claim, meaning you owe him nothing. He owes you nothing. 26. This calculation does not even account for the substantial sums Mr. Boone actually paid her directly, the storage expenses he covered, or the more than $14,000 in attorney's fees he has incurred in protecting the child's best interest against the former wife's persistent obstruction. I love the way that was worded. Accordingly, any claim by the former wife for arrearages must be denied as the equities and evidence overwhelmingly establish that Mr. Boone owes her nothing. 27. For all the foregoing reasons, Petitioner Brian Boone respectfully requests that this court, A, grant his modification petition and deny former wife's outstanding motions, B, award him sole parental responsibility, and I don't see how they could do anything other than that because she can't do any of the responsibilities from jail, C, approve his amended parenting plan, and hopefully add the stipulation only if the child desires to spend the time with her, D, terminate his alimony obligation in order that neither party owes the other any arrearages for unpaid support, E, order the immediate release of any clerk-held funds to Mr. Boone because there was $4,000 in child support he had been paying that is held at the clerk of court's office. F, deny all relief sought by former wife, including claims for alimony, sanctions, contempt, or attorney's fees. She doesn't have any attorney's fees. Certificate of service. So this is being mailed to the pro se respondent by U.S. mail on the 28th day of August at the address provided by her. And then he has his credentials here. So that means in the next few days, she will be receiving this, knowing hers has to be postmarked by Tuesday. So she is probably furiously on the phone. I am going to go ahead and request, put in my request for mid-July through end of August phone call logs. So we'll be able to see who she's been furiously calling during this time. I haven't seen any flying monkeys in the chat lately. So obviously she's got them very busy with this deadline, because she's not going to take responsibility for it herself. And that way someone can type it for her. So it she can put it, in the page limit, because we know she's not going to be concise and to the point. So let me know what you guys think about Brian's closing argument his attorney has furnished, and well before the Tuesday deadline. Today's Thursday. So I'm sure we have the entire weekend to wait on Sarah's to even be postmarked, because she's not one to usually, plus she's mailing it in. I doubt that we'll see it until later next week at the earliest, like this time next week or maybe early the following week. And then once the judge receives all that, we'll receive the final order. But let me know what you guys think in the chat. And if you heard any background noises, my dogs are eating and drinking their dinner while I recorded this. So I do have actually 3 dogs, not just Mr. Snoopers. But sorry if you heard any background noise. I will try to edit out whatever I can. Let me say this. I'm also going to put a post, because Just Hear Me Out reached out to me about asking him any questions we may have about the trip he took down to Orlando and being at the trial in person. So I'm going to post a post in the post tab. I'm going to make a post in the post tab, and you guys can put all your questions you have, and we're going to try to collab on a date sometime next week to to ask him those questions about the trial. So let me know what questions you guys have in the post tab. And again, thank you so much for watching. I'll see you in the comments.